All right, it is Wednesday, March 17th, and I'm speaking with lawyer Eric Bain, attorney Eric Bain. And Eric, real quick, can you tell us what you do in law and what your title is?
Yeah, of course. Good morning, Tucson. I am a criminal defense attorney in Minneapolis, and I own my own law firm, Bain Law.
All right, and we spoke last week, and we'll just recap it real quick regarding the Derek Chauvin trial here in Minneapolis, and a lot of people are watching, and a lot of people are trying to decipher what's going on, and so your insight kind of helps the general public break down what's happening a little easier than kind of sitting through the entire arduous process of a day in court. So I want to ask you off the bat, last week, just to recap this really quick, Murder 3 was re-implemented. What does that mean?
Yeah, so what happened was the defense last fall filed a motion to have the Murder 3 charge dismissed by the court, and Judge Cahill agreed that there was no legal basis for it to go forward. And then it's tied to the Mohammed Nawar case that is maybe a year or two old, because Mohammed Nawar was a Minneapolis police officer who was convicted by a jury of Murder 3. That case is still working its way through the system. So I think oral arguments are scheduled for June at the Minnesota Supreme Court. So it's kind of an unresolved issue in one sense, but in the other sense, the Court of Appeals, which is a court lower than the Supreme Court, has made a decision. And so there was some legal arguments about whether or not that case is precedential, whether or not the Nawar case applies to the Chauvin case. And the Court of Appeals said that the third-degree murder conviction in Nawar was appropriate, so it was upheld. And so the prosecutor in the Chauvin case said, "I'm sorry, Judge, but we believe, based on the Court of Appeals decision, that your dismissal of the third-degree murder charge in Chauvin's case was wrong." And Judge Cahill said, "I think that's right. My hands are tied. I think it's wrong, but the Court of Appeals is the law of the land right now. And unless the Minnesota Supreme Court says otherwise, I think I have to reinstate it."
So what does the reinstatement of Murder 3 mean for this case? Because we go down a sliding scale of Murder 2 to Murder 3 to Manslaughter 2. And you and I in the last conversation kind of, and correct me if I'm wrong, agreed that he'll most definitely get at least Manslaughter 2. I think so. What does the reimplementation of Murder 3 mean for this case? Does it make it a lot easier for the prosecution to see him get murder, since Murder 2 may be a reach for them?
Perhaps, yeah. I think what it does at the most basic level is it gives jurors more options. And whether or not that's a good thing or a bad thing, people can disagree or agree on that. But it gives jurors more options to consider. And it also makes the case a little bit more complicated, because both the defense and the prosecution have to now talk about all three counts throughout the entirety of trial. But getting back to it gives jurors options, many times what happens is in the jury deliberation room, jurors, they have to be unanimous on a decision for each of the three counts. But what happens is sometimes there's some horse trading that goes on in the jury room. And if the 12 jurors split into camps, and maybe it's 6-6, 7-6, 11-1, who knows? But sometimes they cut deals with each other. They're not supposed to do that, but it's really hard. What do you mean by they cut deals with each other? What do you mean by that? Yeah, it happens. So sometimes they say, look, we're not going to agree on everything, and so we can either have tell the judge that we're a hung jury and be a mistrial, or they might say, look, let's just cut a deal. How about we say all guilty on Murder 2, but we, acquit on Manslaughter 2, or something like that. They come up with some combination of charges. So at the end of the day, the more charges that are out there, the more possibility there is for jurors to have those conversations. Again, they're not supposed to, and they're instructed not to do that. And at the end, after the jury gives their verdict, the lawyers can always poll the jurors and ask them, was this your decision? But whatever they say, yes or no, they're kind of stuck with, unless they have other information that this horse trading went on, but they're not supposed to talk about it. So it's something that they're not supposed to do, but it's really hard to enforce them not doing it.
Yeah, because nobody can really be in that room but them, right?
Just them, yeah, and everything is confidential. The door is locked, that can't be mic'd or recorded, so those types of things happen.
That just sounds super intense. I forget the music. I forget the Broadway show. But it's several men in a jury room, and they're just arguing.
12 Angry Men.
Yeah, 12 Angry Men. Yep.
Yeah.
So the city settled with the Floyd family for $27 million, which now makes Minneapolis having the two highest settlements for police violence in the country, with Justine Damon and George Floyd. We had $27 million and at $20 million, correct?
I know that the George Floyd family settlement was 27. Off the top of my head, I don't recall what the Justine Ruszczyk settlement was, but it was quite high.
Yeah, so both of them they're there, and that means and says something to whatever that is. It's saying something. But how does that affect?
Yeah.
How does that affect the trial now? And I believe Eric Nelson moved to have 7 of the jurors stricken from the selection, or what happened? I guess we'll start here. What does the city settling with the Floyd family mean for the trial?
It's a good question, and I'll just say the timing of the announcement of the civil settlement is the problem. Because it's going on in the middle of voir dire, in the middle of jury selection process, and they have this big press conference. They invite the news media. They are inviting this news to be spread everywhere.
Yeah.
And the jurors are not sequestered. They would only be sequestered later on. They're not sequestered during this part of the trial. So, anyone flips on a TV or opens up, the Star Tribune app on their phone, they're going to see it. And that's the problem. And so how does it affect this trial? It affects this trial in the sense that the city is basically acknowledging that they were in the wrong.
Yeah.
Because the city employed Derek Chauvin, and they're saying, look, in a sense, we know he's guilty. That's why we're willing to pay out this record sum of money to settle this. It's incredibly rare for a civil settlement in these types of cases to be reached before the conclusion of the criminal case, let alone announced before the conclusion of the criminal case. So, I don't know whose idea it was. It was a bad idea. It's fine for them to settle, but to preserve the integrity of the Chauvin trial, they should have at least waited to announce it until after the criminal trial.
People are going to be thinking this while they're listening to this. So I'm assuming that some folks are wondering, do you believe this was a move on the city's part to potentially influence the trial?
It's a good question. I don't know. I mean,
we don't know their intentions, obviously.
It's really hard to know. And, the thing is also is the civil settlement is tied to the Chauvin criminal trial in the sense that it all stems from the same horrible, tragic incident. But legally, they are completely separate processes. And so, the criminal trial in Hennepin County, where Judge Cahill is overseeing it, has zero impact on the civil settlement, and vice versa. So Judge Cahill cannot control anything that the city does in terms of the civil settlement, and the city can't really control what Judge Cahill does in terms of the criminal trial. But it raises a lot of questions, and it just looks bad. It just looks really, really bad. Eric Nelson brought up the fact that, the AG's office is prosecuting Chauvin, and Keith Ellison is our Attorney General in Minnesota. Keith Ellison's son sits on the city council in Minneapolis.
Oh, I didn't think about that.
It looks bad. Now, who knows? I'm not accusing anyone of anything. I'm not saying anyone is in cahoots. I have no idea. But it looks bad.
Yeah, I did not think of the Ellison tie. I didn't think about that. That's interesting. Going back to what you said earlier, the civil suit, the criminal suit and the civil suit are both legally separate. So why would Eric Nelson feel that he can strike jurors from this who have already been selected, or possibly try to suggest this should be a mistrial? If they're legally separate, can he do that?
Well, a couple of things. What is happening, what has happened, I should say, where we're at now, is Eric Nelson asked the judge to either delay the trial, and he renewed his motion for a change of venue. The judge has not ruled on those two things. But Judge Cahill did say, look, we're going to bring these jurors back, 9 of them, and we're going to ask them what they know about this.
Oh, man.
Okay?
Yeah.
And, we're just going to ask them, hey, did you hear about the settlement? What do you think? Does it change your mind? And so they've been going through that process. And Eric Nelson didn't necessarily say, get rid of all of them.
Okay.
He's just saying, I'm very concerned about this. And I think rightly so. And Judge Cahill said rightly so, too, because it has the high possibility of tainting the jury pool. And so they've gone through, re-questioning of the jurors that were already seated. And my understanding is that Judge Cahill actually dismissed 2 for cause. And that's important because the lawyers get strikes that they get to use, but it's a set number. And so the lawyers want to be very conservative and judicious with the strikes that they use and how they use them. But Judge Cahill, my understanding, struck 2 of the jurors that were already seated because based on the responses to the questions, they said, yeah, I think this does change my opinion a little bit, and I don't think I can be fair and impartial anymore.
Wow. And
so now we're stuck. Now we've gone backwards a little bit, where we were ahead of schedule, and we had 9 jurors seated. Now we only have 7.
How many strikes does the defense get, and how many strikes does the prosecution get?
Yeah, it's a good question. So typically in these cases, the defense gets 5 and the prosecution gets 3. However, there is a separate process in murder cases in Minnesota, murder 1 cases, whereby you get more strikes. Okay, and so in this case, I believe it's 15 for the defense and 9 for the state.
Okay.
And so they're going according to those rules. And I think that makes sense. I mean, 1, it is a murder case, and number 2, it's just such a high profile case that it has been and is going to be really hard to find jurors that can commit to being fair and impartial because everyone's heard about this at some point.
And so what do you, I guess I don't want to, try to fortune tell too much, but going forward, so we only have 7 jurors now. We need 14, so that's 7 more. 2 alternates that aren't really told that they're alternates at the time, but they end up telling them at the end. And
right.
So we're still kind of ahead of pace here on this thing, correct? If we have 7 jurors after 1 week.
Yeah, I mean, we're sitting here on the 17th. It's Wednesday, so we're about halfway through the 3-week voir dire process, and we have 7 jurors, half of the 14. So I guess right now we're on schedule. Before we were ahead of schedule, but now we're on schedule.
Do you see this trial getting a change of venue, or possibly,
No.
No? Why not?
I think logistically it's a mess. You would have to find, a county in Minnesota a county courthouse somewhere in Minnesota to partner with on this. And I don't know that any county is really looking for the hoopla of all of this.
Yeah, I don't think anybody wants
additionally, it creates a lot of problems because, under the Constitution, every defendant is entitled to a fair and impartial jury, and it's been interpreted over the years to be a jury of your peers. And I think you're kind of stretching the definition of jury of your peers if you have your trial that takes place in, let's say, International Falls, Minnesota, even though the crime occurred in Minneapolis. So then the jurors are going to be from up north, Minnesota.
Yeah, and it was similar to Rodney King when they moved it to Simi Valley.
Causes some logistical problems.
Yeah.
Yeah.
I mean, and that was a strategy to move it out to Simi Valley.
Sure.
Yeah. Lastly, I want to go to Murder 2. Can you explain to us what Murder 2 is? Because in our last conversation that didn't really make it, I kind of like the second that you explained it, I was like, oh, that sounds like what happened in this instance. Can you explain what Murder 2 is again?
Yeah, of course. Yeah, exactly. So murder in the second degree requires the jury to find the defendant guilty beyond a reasonable doubt of all of the following elements. So it has to be, they have to find that Derek Chauvin caused the death of a human being with the intent to the death of that person. But it doesn't have to be with premeditation. So basically, it's an unintentional murder. And it has to happen while committing a felony offense.
Okay.
And so the state's argument is that the felony offense was the assault. You know, you can assault someone by intentionally inflicting bodily harm upon the other person, and Derek Chauvin putting his knee on the neck, that's an assault. You don't have to intend the cause. You don't have to intend to kill the person, but if your felony assault does kill the person and your actions are responsible for it, then that would be enough.
Does this factor in that one of the cops during the kneeling on the neck said, hey, maybe this is a bit much? And then I haven't watched the video, but somebody mentioned to me that this happened. I think we might have talked about this in our last conversation. One of the rookie cops said, hey, this might be a bit much. And then Derek waved him off as like, hey, I know what I'm doing. Will that factor in at all?
I think so. I think that the prosecution is absolutely going to bring that up. That, Derek Chauvin kept his knee on the neck of George Floyd even after his partner said, hey, maybe we should stop. Hey, maybe you should take your knee off his neck. He doesn't look so good. And yet he persisted. The prosecution is going to harp on this 8 minutes and 46 seconds. I believe that's the time period that the knee was on the neck, and is going to bring that up again and again and again, that Derek Chauvin had 8 minutes and 46 seconds to take his knee off the neck, and he didn't do it. He had 8 minutes and 46 seconds to take his knee off the neck with his partner telling him to stop, and he didn't. So, yeah, I think that's absolutely going to come into play. It's going to hurt Chauvin. However, it's going to help that officer. I think it was Officer King that said that, but it's going to help Officer King in his case down the road.
Yeah, and what happens with Chauvin will determine what happens with the other three officers, correct? Because they can't be aiding and abetting a murder if there's no murder.
Right, or manslaughter.
Okay.
That's the general understanding. Now, certainly, if the prosecution wanted to proceed after an acquittal of Chauvin in prosecuting the other cops, they certainly could. But there's going to be a flurry of legal challenges, and I think a lot of legal observers think that the prosecution would have a hard time actually getting a conviction if there's no underlying crime by Chauvin that the other officers aided and abetted.
Got it. Well, is there anything else you want to add or that you've seen in the past few days? I mean, I know it really feels like Eric Nelson is really doing, everything he can to, address, outside elements, all elements, impacting this case. Is there anything else that you want to mention that you've noticed that might be, of interest or that people should know about?
Yeah, it's a good question. I find this whole case just completely fascinating. Cameras in the courtroom don't happen in Minnesota, so the fact that all of this is being live streamed is really groundbreaking. The fact that it's happening in Minneapolis, in our backyard, is really incredible. And I think that the lawyers are doing the best job they can under the circumstances. And everyone this is just a tough case. It's a really tough case. I will say, in terms of something to watch, something that's been interesting, and it's going to be even more interesting once voir dire is done, is there seems to be a lot of discussion about George Floyd's alleged drug use and how much of that the jury is going to be privy to during the trial. And it keeps coming up because it seems like the defense intends to argue at trial that George Floyd died of some type of drug overdose or a combination of some type of drugs in his system, as opposed to the knee on his neck. And what Judge Cahill is kind of saying is, hey, be careful there, because if you go down that path, then I'm going to let the state, then what could happen is those previous drug arrests that you wanted there are these previous drug arrests where George Floyd was arrested with drugs. There was an allegation that he ingested drugs. These are really just attempts to, I think, kind of smear his character and take the focus off of Derek Chauvin's actions as a police officer. But the judge is saying, be careful there, because, if you bring this issue up, these other issues are going to come up that, you guys might not want brought up. So those decisions haven't really been made by Judge Cahill yet, but he's going to have to make a decision soon, and they keep kind of dancing around that. And I guess that's kind of the next thing I'm watching beyond voir dire.
And I guess I have two-part question for you, because we mentioned this in the last conversation. How does your career as a defense attorney shape your view of this? And does it shape your view of this trial? If so, how?
Yeah, so I think it absolutely does, because, I represent people charged with crimes all the time. And, I love my job and I enjoy what I do. And I love that I get the opportunity to help people who are in a tough spot. And I think that every person, no matter what horrible thing they're accused of, deserves fair representation. And so to be perfectly honest and frank, I sometimes, see what Eric Nelson is doing through the lens of my own career and what I do on a day-to-day basis. That being said, I live in Minneapolis. So this city is home to me, and I also am watching this trial through the lens of someone who lives not too far from 38th in Chicago, from someone who, is very concerned about the appalling use of police brutality in our city over the years. And so I am kind of looking at it through both lenses, but as I've been talking to you, Toussaint, for the most part, I am talking as a criminal defense attorney, and the vast majority of my answers and responses are through the lens of a criminal defense attorney.
And the second part and last part, is there any point, because we were just talking about Eric Nelson possibly going for this route of, well, hey, maybe he ingested X amount of drugs or X amount of X, and this is what put him in this state. And Cahill is warning him, if you go down this road, you're going to open up a can of worms that you wouldn't have opened up if you hadn't gone down this road in this court. Is there a part of you as a defense lawyer that's like, oh, no, Eric, don't, that's not the strategy. That's not the move. Is him addressing that or going that route? I know it's strategical. Does that seem like a reach for you?
It's hard to say. I don't know enough about the prior drug arrests of Mr. Floyd to really say. And, I also don't know if there are videos of the prior arrest. So it's hard to say. At the same time, every attorney has to, for the system to work, every attorney has to be a zealous advocate for their client. And they got to at least bring everything up and try and get it out there and, get a judge to rule on some of these things. Because what you don't want is any perceptions by the legal system or the public at large that it wasn't a fair trial. And so I understand what Eric is trying to do, but for me to be able to judge his decisions on those things, it's really hard to say because I don't really know enough about the prior instances, and no one does because the trial hasn't started and the judge hasn't ruled if they're coming in or not. But it's something that's interesting and something to watch. And again and again and again, what we see in police brutality cases is the victim is many times blamed for their actions. Their character is smeared. And it's an unfortunate part of the process. It shouldn't happen. It feels disrespectful. But at the same time, as a lawyer, I get what the defense attorney is trying to do. Yeah. And there is a line that Eric Nelson has to be aware of where if he pushes too far, he's going to piss off some jurors. And, Eric Nelson has to be, he has to be likable by the jury. The jury is judging Derek Chauvin. They're also judging Eric Nelson.
They are. They really are.
Really has to. He has to toe that line, and so does the prosecutor. They have to be likable in the eyes of the jury as well, and so they can't push too hard on any one issue as well.
That's interesting. I never thought about that. I didn't think about that at all. Like they have to. I thought it was just Derek Chauvin was the axis, the here-all, the end-all of their opinion, and it all hinges on that. But it definitely does hinge on Keith Ellison and Eric Nelson as well. Well,
it does.
Yeah, well, we look forward to talking to you in the next few days and just catching up, very briefly on what's going on, just to keep the people updated. Thank you so much for your time, Eric. We really appreciate it.
Thanks, Tucson. Appreciate everything you're doing. Have a good one.
You too. Bye.